Assalamualaikum. We are from Group 1. Today we're going to do a case study presentation in the estate of Hu Wai Kwong. And my name is Nur Atika binti Ahmad HILMI, and I'm going to start first on the fact of the case. First of all, this case is between siblings, the plaintiff and the defendant. The petitioner in this case is Sarah Abdullah, a daughter to the testator named Hu Wai Kwong. The petitioner sought a grant of probate in connection with her late father's will, Hu Wai Kwong, and she claimed that the will was valid, that it met all of the legal requirements. However, on the other side, the other children of Hu Wai Kwong, the deceased together with his wife, acting as the caveators, were not satisfied with the petition on the ground that the testator lacked testamentary ability to make the will, since his mental and physical health was weakening at the time he attached his thumbprint to the will. Right now, we're going to move to the judgment of the case. The court decision, the court held that dismissed the petition as the petitioner has failed to provide evidence to show that the thumbprint belongs to the testator in disposing the wills. Subsequently, the action has failed to comply with Section 5, Subsection 2, in which the requirement for a valid will is signed by the testator. Moreover, the petitioner has unsuccessfully proved that the testator, Hu Wai Kwong, has testamentary capacity as he was sick, unable to understand the nature of the will, and not supported with a medical record to verify the status of his mental health. Therefore, due to the weak evidence provided by the petitioner, Sarah, the will was held invalid. Now I'll pass to my friend for the next presentation.
Thank you, ATIQAH. So I am FARISYA binti KASIM. I will present on ratio decidendi of this particular case. So basically, there are four main points that Loh Hok being judge considered in giving his judgment. Firstly, the will was executed on 29 January 1993, where the testator's testamentary capacity was questioned because the testator was lying on the hospital's bed and developing several health issues, and was then prescribed various medicines. Based on these facts, Loh Hok being judge came to the irresistible conclusion that the testator did not have the necessary testamentary capacity to execute the will on 29 January 1993. Considering his health condition on that particular day, the petitioner claimed that the testator has the mental capacity to think clearly while making the will, in which the petitioner has failed, as it was seen that no further medical checkup was made to clearly identify the testator's state of mind at that material time. Secondly, Loh Hok being judge also considered that all the steps taken to execute the will were indeed taken and implemented by the petitioner, who becomes the prime mover, while the testator was presented with a fait accompli. In his considerations, the change to a new solicitor to execute the plaintiff's will, notwithstanding that the testator has never spoken to the testator regarding the disposition of the will. It is a bizarre situation and creates absolutely dubious, devious, nebulous, and suspicious circumstances. The petitioner's action in changing the testator solicitor to the petitioner was enough to raise suspicion by the court. It can be seen that the petitioner's solicitor was the one to prepare the will. The court thought that the will had been tampered so that its condition was to the benefit of the petitioner. Hence, it creates the suspicious circumstances that would be amount to fraud of the will. Now, I'll pass the next 2 points of ratio decidendi to my dear friend, AQILAH.
Thank you, FARISYA. So I am AQILAH NADHIRAH, and I'll be presenting on the third and the fourth point of ratio decidendi. So the third circumstances is that the petitioner also had failed to prove that the thumbprint on the attesting clause belonged to the testator. This as per evidence of the fingerprint expert, who could not prove that the thumbprint is the testator's due to the lack of essential characteristic. Therefore, the petitioner has subsequently failed to prove that the testator has executed the will as required under Section 5, Subsection 1 of the Wills Act 1959. The fourth part is that it could not be proven whether the content delivered by the petitioner in the will is accurate or not. It was held that the petitioner's solicitor prepared the will. As stated earlier, the testator has never spoken to the solicitor, in which the petitioner then reads the will in English before translating it to Hakka. As the testator does not understand English, it creates ambiguity and uncertainty as the two attesting witnesses who present during the process do not understand Hakka but understand English. It cannot be proven that the statement read in English and explained in Hakka to the testator is the same, as the petitioner may change the content of the will while explaining it to the testator in Hakka, thus resulting to the testator agreeing to the content of the will. Next, I'll pass the presentation to Farahin.
Hello, my name is NURFARAHIN, and I will be present on a part of obiter dicta in this case. There are a few remarks or opinions given by Lohok bin judge in this case. Firstly, he made a remark on the conditions of the valid wills, where valid wills is when the testator must be able to understand the nature of the act and its effect and the extent of the property of which he is disposing. And he must be able to comprehend and appreciate the claims to which he ought to give effect and the manner in which his property is to be distributed between them. However, in the present case, the deceased condition when executing the will was in question when all those medical facilities were equipped on his body. Second, in regards to the changes of the testator usual solicitor, he believed that a testator would normally refer his usual solicitors relating to alter the will or dishenry relations. So he cited the case of Baton Singh against Armikant, where there is a similar facts with this case. Therefore, in this case, he raised the suspicion that the solicitor prepared by the petitioner is the same as having that solicitor act as an agent for the petitioner.
Hi, my name is ADILAH HANIM. So for the legal opinion, in this current case, it seems that the judge relied on two issues in giving his judgment, which are mainly concerned about the testator's testamentary capacity and circumstances which give rise to suspicious circumstances. Firstly, referring to the suspicious circumstances point of view, the petitioner was unquestionably and unequivocally the primary mover in preparing the will. Suspicious circumstances may be one of the grounds to be challenged in the court in terms of its validity. So from this present case, we agree with the judge's decision of the court to dismiss the petition, since one of the requirements of a valid will is that the propounder of a will must also eliminate any questionable conditions hiding behind the will's execution. Next, I pass to Putri.
Hi, my name is PUTRI SABIHAH binti PUTERA. So the second one is the court also look into the validity of the will may also be challenged through the testator mental capacity, in which a testator must understand the nature of the act, its implication, and the scope of the property he will dispose of. In the case Bank and Goodfellow, the court in his view stated that in determining the testator's capacity, he must, in the language of law, have sound and disposing mind and memory, meaning that he should be able to make his will knowing the type of the business in which he is engaged, the collection of property he intends to dispose, the persons who are the beneficiaries of his bounty, and the manner in which he is dispersed among them. Therefore, the testator needs to comprehend and appreciate the claim in which he must bring benefits in showing testimony ability fall on the individual claims on the will's validity. Next, I'll pass the floor to AMANY.
So, for the third, no evidence was adduced before the court to prove the statement. In the present case, the will was alleged to be executed by the testator, an elderly and infirm man lying in a hospital bed with all the frailty, weakness, and helplessness it entails, with no record of medical examination or conclusions. Nevertheless, the testator was admitted to the hospital due to the inability to pass urine. As such, various medicines were given, and in fact, the medicine might have effect his brain and awareness. However, no evidence was adduced before the court to prove this point. That circumstance render the petitioner's attempt to establish the testator's testamentary capacity absolutely futile. As a result, the will was declared invalid. Thereby, the court is reluctant to believe an older man in such severe condition is capable of executing the will and has sufficient testamentary capacity at the material time.
So that is all from us. Thank you.